Your Honor, I do have an announcement for Mr. Bowie.
Ready.
Judge, this is, I have Mr. Bowie here next to me, Judge. So Mr. Bowie does wish to enter a not guilty plea today,
Okay.
although he also wishes to ask the court to set a bond on his case. He is held on this misdemeanor offense with no bond. My understanding is that at the time, the magistrate court did not issue a bond because he was on probation. However, he is no longer a probationer. I've discussed this with Ms. Hagler, so I believe that she's aware that he is no longer a probationer. Additionally, Judge, the alleged victim in this case is on the Zoom call. So the alleged victim will have which is his son, is logged on as iPhone Bless. So, Judge, we would just ask that the court go ahead and set a reasonable bond on Mr. Bowie's case because he is entitled to a bond on his misdemeanor offense, Judge. And he has been incarcerated since March 6th, my understanding.
And Your Honor, the state would object. The defense counsel has not filed a motion to modify his client's bond. We have not been put on appropriate notice. And so the state is not ready to argue for any type of bond. Is not ready for this bond hearing today. So we just ask that the defense counsel will file this motion that way the state can be placed on proper notice and make the proper arguments.
And Your Honor, you're muted. Judge Hayward, you're muted, I believe.
Okay.
Can I respond or did you want to go ahead?
Respond.
Judge, so I think that based on the fact that if he's not a probationer, he's entitled to a bond on a misdemeanor offense. The alleged victim is here. I believe it's well within the powers of the court to set a bond for him today. And I believe in the interest of judicial efficiency, there's no, and I don't, I understand she wants me to have to file a motion so that there'll be more time where my client has to sit in jail. But I think we're here today with all the parties. And I would ask that, the court set a bond on his case. And his son is asking to be heard as well through chat.
Your Honor, at this time, again, the state is not ready to proceed on a bond hearing. So
all right, let me ask this. Does he have a history of violent offenses?
My understanding is no, Judge.
Well, he does have, I did see a few probation violations. That was just from the Cobb County one in 2023. I do see that he has a New York history as well.
I want to know about that. I want to know if in Georgia, in the recent past, last 5 years, does he have any violent history?
1 second, Ron. Let me go back to the Georgia one. I do see a fleeing attempting. That was 2023, and that's pretty. That would be the most recent in Georgia. But again, he does have out-of-state history, Your Honor.
Okay, he has no bond on any of the 4 offenses.
Correct. And Judge, I don't.
And Your Honor,
No, I'm sorry.
I was just
stop. Everybody stop. Hold on. First of all, I got a witness texted, chatting, saying he was told he would be allowed to speak. Well, that's only if we have a bond hearing. I'm not sure I'm having one. I'm asking questions right now. Number one. Number two, who's the alleged victim in this case?
That would be his son.
Okay, the person who wants to talk to me?
Yes, Ms. Bless Bowie. I believe that's.
Your Honor, I would just ask for a moment to be able to speak to the witness. As it has been stated before, counsel doesn't represent the victim or any witnesses in this case. His best interest is his client. I think it's inappropriate for counsel to make statements on behalf of the victim in this case. I don't know what conversations that counsel has had with the victim.
At which point did I make a statement on behalf
I'm sorry, Mr. Lynch. I'm just letting the court know the state's concern. Okay. I would ask that if the court is inclined to have any motions hearing over the state's objection, if we can have a moment so that it is not a motion by ambush by council. We were not made aware of this prior.
All right.
And so I would just
This
ask
what
for
I'm
a
gonna do.
couple of
I'm gonna give
moments.
y'all 10 minutes to talk about talk to whoever you need to talk to. Give me the information you need to talk to on Mr. Bowie, review his record. And then if after that 10 minutes, we'll talk about it. All right.
Thank you, Your
Anything
Honor.
else?
May I have a breakout room with the victim, Ms.
You may.
Hemphill and Ms. Hagler, please?
Sure.
Thank you.
Can I just say one thing?
Sure.
You know, at no point did I make a statement on behalf of the victim or attempt to speak from the victim. I would not do that. I don't appreciate that assertion. I said he wanted to be heard. And that was what his own words on the chat. Didn't make any statements on behalf or purport to represent the victim. Thank you very much.
All right. Gotcha. All right. So I set up the breakout room. It's open. Y'all go in there, y'all talk, and I'll be back in about 10 minutes. Thank you. All right. What's going on?
Better roll.
Yes, Your Honor. Again, the state is objecting to proceed forward without a motion being filed, but if the court is inclined to still proceed, the state is ready to proceed.
All right. Mr. Lynch, the state is entitled to have time to prepare. It's not just that they look at his record, which they have access to, but they also entitled to do some research, to talk to people. So when we get these situations, I know he's an active inmate, and I know he's entitled to have his bond reviewed if the conditions for denying him bond have disappeared, but a motion can still be filed. And so to continue to spring these on to the state and then call it judicial efficiency, I just don't think that's fair.
Judge,
Okay. I understand, like I said, I was a magistrate, so I understand 1710-1, 1761, and how bond can be denied in cases such as this. However, they are entitled to the same, I have to be fair to both sides. And so just like you're entitled to bring a motion for bond consideration on behalf of your client, they're entitled to be prepared to argue a motion for bond consideration. And so everything is not an emergency.
well, hold on. Your Honor, I understand the argument about notice, and if that's the court's decision, then that's something we'll live with. However, I'm making a motion to set a bond for my client who's entitled to a bond right now. And I would ask that if you're not inclined to hear that today, that you place it on the next jail calendar so we can be heard at that time. The state has put on notice right now that my client is seeking a bond which he is entitled to. And my client has been held in custody without bond for at least some period, into which our position is that he's entitled to a bond. Judge, I didn't know that he was.
All right, so let me ask you this. So it's my understanding. So if magistrate court was disinclined to set a bond based on the fact that he had a prior probation or parole, what happened with that condition? What happened with that?
His probation out of Cobb County has recently been closed, Judge. So he's not currently on probation with Cobb County. Okay,
and when was that closed?
It appears to have been yesterday, because he was on a 2-year probation in Superior Court of Cobb County, March 31st of 2023. So yesterday is ended the 2 years as we're in 2025. So it was still in place when the order was signed on March the 7th, though, by Judge Parker, the bond order.
Okay. So he was denied bond on March 7th. The probation just closed yesterday, March 31st. So he wasn't entitled to a bond on misdemeanor under 1710-1 and 1761 until today, is what you're telling me.
Based on the information that I have, yes, Your Honor.
Yeah. So the condition that would have allowed him to have a bond set just went away yesterday.
Correct. But again, the defense counsel still needs to file a motion to put us on notice.
So I don't, the state keeps referencing that defense counsel file the motion. I don't believe they're citing any
Everything okay?
that requires
Who's
that.
talking?
The
Miss
state-
Hemphill, you need to mute your phone, please. I mean, mute your mic, please.
Oh, you left your money at the house Karima gave?
Miss Hemphill,
All right,
I'm
got it.
making a oral motion to set a bond on his case right now. I will file the written motion today, but Judge, I need you to stop talking. Judge, I believe it's well within the power of the court to set a bond.
It is, Mr. Lynch. I'm clear what my power is. You know, they teach us at judge school what power is. I go to the classes, I learn. But the problem is that a lot of times when we have somebody who's in a situation where I get it. I get that the default on a misdemeanor is to grant a bond. I get that. But there are also situations in which the denial of a bond on a misdemeanor is proper. And I know that too, because I was trained on that. So what I'm saying to you is the condition precedent that would have allowed the magistrate court to deny him a bond was still present until yesterday. And so what I'm saying is your emergency does not make an emergency for the state. They still get to do the due diligence necessary to weigh in on whether this person should have a bond. Yes, it's a misdemeanor. And what type of bond he should have, what type of conditions should come with that. They have to, they get the opportunity to talk to the people who witnessed whatever it was, the people who were involved in whatever it was. And so what I'm saying to you is, you would not like to be ambushed in that way when somebody rolls up on you and says, hey, we're going to do this today because, well, you know, I'm bringing it up now and the judge has it within her power to do. I have a lot of things within my power to do, and my job is to balance it so that I'm fair and I protect the rights, the constitutional rights of the defendants, but I also have to be fair to the state. And what I don't want to get in the habit of is just because somebody's in an orange jumpsuit, it now becomes an emergency because they had a condition that made them not eligible for bond before, but now all of a sudden they're eligible for bond and I have to jump through hoops because now they want a bond. We're going to put this bond here and off to next week. You'll file the motion today and we'll start doing that more often than not. Okay, because every time somebody comes up and they don't have a bond down from magistrate court, it does not make an emergency. It makes an opportunity to examine the conditions as to why in a situation where a bond is the default for a misdemeanor, why a bond has been denied. So in this case, y'all can do one of two things. You can negotiate, and now that the condition precedent for denying the bond is gone, you can send over the information and ask for a consent bond, or you can be put on the next available jail calendar, and then we can talk about a bond. And have a bond hearing, but everybody's entitled to notice. And so when you just say, well, it's in your power to do it, judge, but how often am I supposed to just deny them the opportunity that they have to prepare?
And I understand the court's position, Judge. I also think that under the Constitution, pretrial incarceration, you know, is to be, you know, it's not supposed to be punitive in this case.
I'm not saying it's punitive, Mr. Lynch, but I don't know anything about the case. And what I'm asking them to do is opine as to the type of bond they would suggest, the conditions of bond would suggest, the situation having to do with, I just talked to a probationer who, in the situation she's in, she was the one convicted of the battery, but the situation looks like it may have been a domestic violence and she might have been a victim of the situation, but she asked for no violent or harassing conduct. And I'm contacting, I'm going, okay, maybe that's something that should not have been granted in that situation because it looks like maybe she's the victim. And so I'm gonna be more intentional about hearing what I need to hear before I just modify conditions and grant bonds. That's just it. I'm entitled to to have a hearing where people are prepared to argue, just like I did downstairs where I was sitting by designation as a Superior Court judge. We had a time, for bond hearings for everything from murder on down. And we have the opportunity for people to prepare for those hearings. Just because it's a misdemeanor doesn't mean the state doesn't get the opportunity to prepare. Everything is not an emergency. And while I respect the fact that pretrial detention is not to be punitive, in a situation where I have to weigh whether there's likely to be another situation between these parties, then I should have the opportunity to hear from a prepared both sides. So just because I can do it doesn't mean I should. And that's the thing that comes with wearing the robe.
And Judge, I would.
If you are supposed to zealously advocate for him as your client, and I get that, and I say, do that. But the state also has a client, and they're supposed to zealously advocate for the people. And when I take from them the opportunity to be prepared in a bond here, because I'm gonna just say, well, he's coming up, and I've done it several times, but I need you to understand that that's not gonna happen every time. All right, so he's going to be put on the next available calendar if y'all work something out between now and then. But yeah, we need to do a sooner one, Miss Val, because of the nature of the detention. But yeah, you need to file that motion today.
Sure, Judge. My client did want me to. My client contests the fact that he was still on probation, but I don't have anything to back that up.
I got that. I'm fine with that. But the whole point is the magistrate court did it right. And the condition that they used to deny him bond didn't end allegedly until yesterday. And so once that ended, file a motion and then we'll have the bond hearing. But just because it ended yesterday, that does not make an emergency today. Okay?
Okay, you're not helping yourself right now. Judge, at this point, I understand what the court has ruled, and I'm not going to, and I don't think that I'm going to be successful in undoing that. I would just point out that you did say something I agree with. You said just because I can do something doesn't mean I should. And I would just point out that that also applies to the magistrate court when they're denying bonds every chance that they can for any little reason.
But let me explain to you how it works, because I've sat in that seat. When you have a situation where violence is the issue, where it is a battery, a simple assault, as a magistrate, you get 5 minutes to look at the paperwork and to review what a police officer has given you. And we have, as magistrates, access to the criminal file. So the GCIC. When we look at that and we see probation and parole, we don't have the opportunity to call Cobb County and say, hey, let me speak to the probation officer and let me get a full and fair and complete understanding of why he's on probation. What this is, all we know is violence, probation. Probation should have the opportunity to opine as to his ability to get out of the situation that he's in. So yeah, no, the magistrate court, when they follow those rules, they're following them to the letter because they are constrained by the fact that a first appearance hearing happens within 48 to 72 hours of the person being arrested. And sometimes it's shorter than that. So they're going on the information that they have at the time, which is appropriate. If all they have is the GCIC and the police report, and it says on their probation or parole, that is the reason 1710-1 and 1761 are in place, because at the time, their first duty is to make safe the community and the person who is the alleged victim in that case, and possibly even the defendant, to keep the peace. And they do that by looking at that. So when you say, well, just because they have the ability to deny, if they had more time, if they had somebody who was prepared to argue a bond hearing at the first appearance, then maybe they wouldn't have to do that. But that is not the mechanism we have. And so what I'm not going to let you do is just decide that the magistrate court, by exercising this legal right that they have, is wrong to do so, because they're not. The whole point is to keep the peace. And if what their indicators say is, hey, we need to slow this down so that the probation or parole officers or the judge involved in those cases can maybe get some notice that here he is, we have him, then that's what they do. Now, this may not be the case where Mr. Bowie is one of the people who their probation or parole officer has been like, okay, we've been looking for him. Thank goodness you got him. Let's slow this situation down so we can review what's going on. But that's the mechanism. And so you don't get to for somebody who's sitting in that seat and who has the limited tools of, I've only got the GCIC and I've only got what the officer has put on this thing. They don't have the opportunity to speak with somebody who's the alleged victim in that case. They don't have the opportunity to speak with somebody who is the probation or parole officer. They only have those tools. And so when you say, well, just because they can, they shouldn't, well, you're saying, they know the whole situation and they should act as if they know the whole situation when they don't. And I can confidently say it because I did it for 4 years. Okay, so now that I am in the position where I actually get to give some time to review the situation and to determine whether it is appropriate and how much of a bond it is appropriate to set, then yeah, I'd like to be able to get people to be prepared to tell me exactly what I want to know. I can run and gun if I want to, but is the right thing to do? So you zealously represent Mr. Bowie. I will continue to maintain the balance between his constitutional rights and the right of the state to defend the citizens of this county as they see fit. But just because their client is not in jail doesn't mean that they don't have the opportunity to have notice and be prepared for a hearing. Okay? And so we don't just stop every time somebody doesn't have a bond. We need a hearing right now. Not doing that. There may be some cases where it's appropriate, some cases where it's not. We clear? All right. So we're going to reset Mr. And unfortunately, I don't have another hearing date until April 15th. So if y'all work something out, that's fine with me.
I lost everything. And my son is homeless and I lost everything. My son is homeless and I lost everything.
Work it out. Because if you don't ambush somebody, then it's like more than likely you can work it out. If they have the opportunity to speak with the alleged victim in the case and they have the opportunity to look at his record, maybe talk to the parole officer or probation officer, and you tell them, hey, this condition just ended, can we work something out? That's one thing. But when you just ambush somebody and say, well, let's push through a hearing and they're not prepared, they're less likely to work with you. But let's try that. Okay. So this is my understanding that this is Mr. Bowie is entering a not guilty. I'll accept his not guilty. We'll set the bond hearing for April 15th. If y'all come up with something before then I will sign a consent. But that is it today.
Thank you, Judge.
All right. All right.
And Judge,
Anything else?
I just want to say, Mom, I didn't mean to imply any malfeasance on the behalf of the magistrate court. My comment is just based on the fact that I see more often than not everyone getting denied bond in any case where
I get it, Mr. Lynch, but what I tell you is, first of all, magistrate court is the busiest, most chaotic court that you can ever serve on. And in fact, it is my honor to have served there because it made me the judge I am today. When I tell you that in magistrate court, you are hit with so much in one day. If you're on criminal, if you're on civil, if you're on intake. So every one of those days is chock full of information, cases, people, review. So when we're doing a hearing like this, and I might have 10 people on my hearing, if you're talking about magistrate court on first appearance, they can have 30 people coming in on first appearance. And they're having to review that information when they get in at 8 o'clock in the morning until the time that they have the hearing. All they have is the GCIC for each person. It is not where they get to spend hours looking at this person's history or their record and then make a decision. We're talking 10 to 15 minutes maybe per person if they have that. And so they are making the most reasoned decision that they can make. And when, somebody who has the benefit of time gets to then say, well, maybe they're saving lives. You ever think about the fact that when they're denying a bond, they may be saving a life, but we might not know it? They're doing what they're supposed to do per the law that they have before them, per the facts that they have before them, per the time that they have to deal with the situation before a whole new crop of people come in for the next 24 to 72 hours where they have to have a first appearance hearing in that period of time. And we're not just talking about misdemeanors, we're talking about major felonies. They see everything. Like I said, from murder on down to ordinance violations. And so when you're talking about judges who deal with that volume of cases, who deal with that those levels of cases, and they're able to make distinctions, they're able to put cases where they need to be. If it's a felony and they see that it should be downgraded, they're able to do that. If it's a misdemeanor and they think it should be upgraded, they're able to review that and do that. You can't impugn the ability of the magistrate court and those judges to do what needs to be done in the short amount of time that they do it. So when they err towards keeping people safe and keeping the peace, I can't fault them for that. All right. So that's all I got. Talk to y'all later.